After the United States Supreme Court issued a major order denying emergency review to a state's original Second Amendment Preservation Act challenge, the law remained locked down under a sweeping federal injunction. But an explosive new twist has just developed. During the Supreme Court's proceedings in this case, the Trump DOJ made explicit promises to the Supreme Court that essentially the DOJ would step in to narrow the injunction and protect the state's right to non-enforcement of two-way issues. Months have now passed and the DOJ has completely failed to act on that promise. And now, tired of waiting on the federal government to actually honor its word, state legislators have moved forward with their own introduction of a new Second Amendment protection law. The state is fast-tracking competing frontrunner bills to completely cut off state resources from federal overreach. So in this video, we're going to break down what exactly happened and what the state is doing in response to the Supreme Court denial. Now, before we jump into this very critical two-way legislative battle that is currently unfolding, if you want to support the channel, make sure to hit the subscribe button and also turn on the notification icon, the notification bell, to make sure you get information when I release it on these type of topics. Now, to understand why this whole Second Amendment Preservation Act kind of 2.0 law is such a massive escalation, we have to look at how this actually got here. So essentially back in 2021, Missouri passed its original Second Amendment Preservation Act to draw a very clear line in the sand on this issue. It declared that the state and local officers could not assist in enforcing federal restrictions that violated the Second Amendment. And so essentially backing it up also, they added in a civil remedy allowing their residents to sue local agencies if they cooperated with federal overreach. The law relied strictly on the established constitutional anti-commandeering doctrine to put in place this law. Predictably, the federal authorities and the federal government, then at that time the Biden DOJ, immediately sued the state, and a district court on review struck down the entire law. Responding quickly, Missouri fast-tracked an appeal up to the U.S. Supreme Court seeking emergency relief, but the High Court at that time rejected the emergency stay in an 8-1 vote, with only Justice Thomas dissenting in favor of the state. This then went back down to the lower court, to the Circuit Court of Appeals, who on review actually struck down the entire law on the merits. That then led for the second time Missouri to file their second petition for Supreme Court review, which ultimately the Supreme Court denied that emergency relief. So for the second time, the Supreme Court stepped in and denied review of this case. But the issue really is why the Supreme Court denied the final review to this case that really triggered what is now going on in the state. By the time this case reached its final stages in the Supreme Court, the Trump administration had taken over this case. While the Trump DOJ still argued against parts of the original SAPA law in Missouri, they made a massive concession that the Supreme Court actually latched onto. They explicitly admitted that the lower court's total injunction went too far by blocking basic state non-enforcement of this law. The DOJ gave the Supreme Court its actual word that if review in this case was denied, the federal government would voluntarily step in to narrow the injunction and restore Missouri's right to keep its resources out of the federal hands. Missouri actually aggressively warned the Supreme Court and the justices not to trust this promise by the DOJ, arguing that it was actually just a stall tactic. However, the Supreme Court ignored that warning, took the DOJ for its word, and denied review of this case once again. Now, seeing the federal government actually breaking a direct promise made to the Supreme Court highlights exactly why you cannot rely on shifting political administrations to protect your liberties. Instead, you need elite, unconditional legal defense in your corner. That is why I'm proud to partner with attorneys on retainer. Unlike standard insurance-backed concealed carry programs that can drop your coverage at any time for pretty much any reason, AOR is backed by a real law firm, a real aggressive law firm, with attorneys that want to take your case. If you're forced to protect your life or your family, they put actual trial lawyers in the courtroom that you know to defend your freedoms. Right now, they are offering my viewers an exclusive opportunity to secure this protection. You can use my custom code ARMSCHOLAR at checkout to get $50 off of your individual sign-up fee or $25 off of your family fee. So don't wait for a broken promise from the federal government or from a law enforcement officer that will actually just leave you exposed. Now, jumping back into what is going on in this case, essentially Missouri's worst fears have now been completely realized. Months have passed since the Supreme Court order, that denial order, and the Trump DOJ has completely refused to move to lift or essentially narrow that injunction. They have completely ghosted on their promise that they made in the high court. But Missouri is not backing down. They're not going to just take that and just say, well, we got ghosted. They made a promise. They didn't fulfill it. And therefore, we're not going to do anything. Instead, Missouri is actively acting on this issue. Because of this kind of federal inaction, state lawmakers are officially launching a SAPA 2.0 effort. This isn't just a symbolic gesture. It is essentially a full legislative battle with multiple bills moving through the House and the Senate to bypass the DOJ entirely. Right now, two powerful frontrunners of bills have emerged in the Senate and also the House, and really the Senate ones are kind of leading the charge. The first major bill to watch for is Senate Bill 858. This is kind of being hailed as the true hardline successor of that original law. SB 858 keeps the core mandate fully intact, essentially that Missouri officials are completely barred from assisting with federal overreach. But to make sure local agencies actually completely comply, it retains that aggressive enforcement mechanism that made the original law famous, including heavy civil penalties and severe legal consequences against any local agency or department that cooperates with federal enforcement. This is kind of the underlying anti-commandeering approach, and this is the more hardline approach. Now, on the other side of the aisle kind of sits the primary competitor, that is the Senate Bill 955. This bill takes a significantly altered kind of structural approach. Instead of going all in, SB 955 softens the restrictions, explicitly allowing more cooperative kind of windows for federal agencies. Now, crucially, it completely removes or essentially severely limits the civil liability concerns that had local law enforcement groups fiercely opposing the original version of SAPA. Because it protects local police budgets from civil lawsuits, this kind of moderate version is heavily backed by law enforcement associations across the state. So this leaves the legislator at a historic crossroads. Lawmakers are currently testing the waters to see which version can command the most political support. Do they essentially pass the hardline SB 858 anti-commandeering kind of doctrine, which is very much more in line with the original SAPA law, or do they compromise with the law enforcement friendly SB 955 to ensure that it survives future legal challenges? The critical difference in SAPA 2.0 is that both bills kind of clean up the original language that caused lower courts to eventually strike them down. Instead of trying to retroactively declare federal laws unconstitutional or invalid within the state's borders, essentially these new bills focus purely on the state's absolute constitutional right to simply say, no, we are not going to participate in your enforcement actions that violate the Second Amendment. So Missouri is tired of waiting on the DOJ to fulfill those promises that they made to the Supreme Court. The legislative battle is officially on right now, and whichever bill wins will set the blueprint for state preservation laws nationwide. So as soon as either SB 858 or SB 955 clears the final vote as it moves forward, I will bring that straight to you guys. If you appreciate this type of reporting, if you appreciate this content, make sure you like, comment, and subscribe. All of that helps to support this video and push it more to more people who want this information. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.